This is Michael Popok, and it's time for Legal AF After Dark. We just got through talking about Jack Smith and his next moves in the Lago case. Now that Judge Cannon has made what appears to be a reversible error in her decision about whether to release confidential, private information about a dozen witnesses that she wants released to the public when they would put those witnesses, judges and prosecutors, in harm's way. It's a violation of the 11th Circuit law, and she applied the wrong standard legally to boot. Is this the opportunity Jack Smith's been waiting so patiently for, to go to the 11th Circuit Court of Appeals and not only seek the reversal of Judge Cannon, but to seek her removal as the trial judge? We cover it on Legal AF. Take a listen.
Let's talk about what's going on before Judge Eileen Cannon. In that case, there's purportedly a trial date still for May of 2024, but we all know that that's completely a joke. May 20th, 2024 will not. That trial date's not going to happen. There's supposed to be a status conference March 1st of 2024 to kind of deal with where everybody is in this case. Trump also filed another motion to try to adjourn other kind of filing dates and deadlines that he should have filed things back in November, with Special Counsel Jack Smith called him out for. But, what Donald Trump's trying to do in that case is a combination, his whole strategy, knowing that he's got Judge Eileen Cannon who's complicit. The strategy is gray mail, threaten the Department of Justice that they will basically take the classified information in the case and try to make it public to undermine national security unless the case is dismissed, and also threaten and intimidate witnesses who are subject not to necessarily the SEPA protective order, which deals with classified information, but some of the standard things that take place in federal criminal proceedings that are subject to the standard federal criminal protective order, which says that discovery materials and that you have to turn over to a criminal defendant. You usually have to turn over to a criminal defendant if it's, exculpatory, or there's certain time for when you have to turn it over if it's inculpatory, but you could wait until the time of trial when it comes to a set of documents called Jenks material. But Trump wants to make that information public, like the identity of confidential witnesses and confidential witness reports with the government and FBI code names, the types of things which form the very essence of why you have protective orders that are entered in these cases to keep the information confidential, meaning the defendant can see it, the prosecution can see it, but the public can't see it because it could jeopardize other criminal investigations. It could result in stochastic terrorism, where other people will then go after these witnesses. It could incite a criminal defendant to try to, put someone's name out there and put a hit on people. So there's all of these reasons why you keep this information confidential under a protective order. The standard for keeping information confidential under a protective order, when it's discovery material turned over by the government to a criminal defendant, is what's called a good cause standard. Is there good cause for the government to want to keep this information confidential? And that's a fairly easy standard to meet. However, when it comes to filing things on the public docket, because there is this presumption, of course, that court proceedings are meant to be public, the same way if you were in a courtroom, the public docket has this kind of sacrosanct First Amendment view towards it. And so the issue there is it's a different standard than is there good cause to keep this information confidential. The standard is there a compelling governmental interest that is narrowly tailored that overcomes a First Amendment presumption? So a compelling governmental interest is a harder standard to keep something confidential when it's on the public docket. So here's the scam. It's such an obvious one, and there's case law that protects against it. But here's the kind of, amateur lowbrow scam that Trump basically did. It's why I wanted to give you that framework so you can kind of understand it. Trump goes, let me take all of this discovery material that I received, which is confidential under the good cause standard, and which includes the names of all of the confidential witnesses in the case and FBI code names and confidential witness reports. What I will do, Trump says, or Trump's lawyers say, is I'm going to file a frivolous motion to compel and just make up that the government hasn't turned over things, which they did turn over. But why I'm really doing this is I want to attach as exhibits all of the witnesses, all the confidential government documents, to throw it on the public docket. And then Trump goes, I'm going to argue that this should be released because the government has not shown a compelling government interest. Wink, 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 Judge Eileen Cannon. So Donald Trump files the motion to compel, includes at first redacted copies of all the confidential witness stuff, and then tells Judge Eileen Cannon, and Trump phrases it in a very mischievous way. He goes, I want to file redacted copies on the public docket. But what Trump really meant was to remove the redactions, as Special Counsel Jack Smith pointed out, on all of this information of confidential informants, confidential witnesses, FBI code names. So Special Counsel Jack Smith responds to that and says, look, of course this stuff should remain confidential pursuant to the protective order. This really isn't a major, issue. It should be very simple. Keep it confidential. Judge Eileen Cannon earlier in the week issues an order saying that, Jack Smith, you did not meet the compelling government interest test. You did not show why your confidential witness list, your FBI code names, why there is a compelling government interest to keep those witness lists, to keep the FBI code names, to keep those confidential government reports secret from the public docket. Again, Trump has access to them, just like Jack Smith does, but keeping it outside of the public docket. And when I saw that ruling from Judge Cannon, it was horrifying. She's going to get somebody killed. And it should be so obvious that this information needs to be confidential. It's so rudimentary that you do not want to expose the names of confidential witnesses in the discovery process, who may not even be witnesses at the trial itself, from public disclosure. It's so well known across the country. And by the way, some of the material that Jack Smith turned over earlier, just to try to be meticulous and try to expedite the proceedings, is material that the criminal defendant, it's called Jenks material, would never even get until after the confidential witness testified at the time of trial anyway. Jack Smith turned it over early to try to expedite the proceedings, but because there was a protective order, and Donald Trump says, I want to make that info public, and Judge Eileen Cannon's like, yes, let's make it public. So Special Counsel Jack Smith filed this week on Thursday a motion for reconsideration, a precursor to an appeal of Judge Eileen Cannon's order, and basically said, Judge Cannon, you applied the wrong legal standard. Number one, it's not a compelling government interest to keep it confidential off the public docket. You have to apply the discovery standard. Just because Donald Trump takes the discovery and attaches it to a frivolous motion to compel doesn't convert those confidential documents into public docket documents that are subject to a compelling government interest test, Your Honor. It is still the good cause standard. So you applied a clearly erroneous standard by saying that the government failed to show a compelling government interest about why these documents should remain confidential. It should be a good cause standard, which we clearly meet that standard. And then Jack Smith cites the 11th Circuit case, which just says that in no uncertain terms. She didn't follow the most basic law. But then Jack Smith also says you would also cause manifest injustice even if you used a compelling interest test, there is a compelling interest here. The compelling interest, Judge Cannon, is you are going to get people killed if you disclose this information. And there have been many, many witnesses who have been threatened here and in other cases. And it is well recognized that a compelling government interest in general is protecting witness safety. So
The
even though
judge has been threatened. There's a woman who just got sentenced to 3 years for threatening Cannon in this case in Texas.
Judge Chutkin was the one threatening.
No. Judge Cannon has been. There's a woman in Texas who just got sentenced to 3 years for attacking Cannon in the Mar-a-Lago case because she thinks she's siding with Trump. So and this is what Jack Smith was referring to when he said in his briefing, even your chamber and you have been threatened in this case.
And so there you have Jack Smith saying, look, you're applying the wrong legal standards. You're making this is an egregious error on a very simple issue. Popok, this is the type of mistake or intentionally malicious conduct by a judge. She's finally made a ruling. It still was not like a ruling on a substantive motion to dismiss or anything. It was still an odd ruling that she's like, yeah, make the confidential informants and witnesses public. But that's the kind of mistake or intentional malice that we've been waiting for, that Jack Smith has been positioning for, where he can finally go to the 11th Circuit. And he's doing it the right way, too, by taking this another step to say, we're giving you another shot right here and showing you how, because he could have went to the 11th Circuit directly,
right,
but wants to kind of lock it in that even when presented, you're going to do the wrong. I thought it was a brilliant move by Jack Smith, but finally the walls are closing in on him.
I agree. The 11th Circuit, as you've noted in the past, and I've referred to it in a hot take, has a lemon law. Basically, if you screw up 3 times on substantive issues in a case, you may have disqualified yourself as being the presiding judge over a complicated case. And we're watching now. She's already screwed up twice. She had 2 appeals and reversals before the case even reached the indictment phase, when she tried to interfere, Judge Cannon, in the search warrant and the continued investigation of Donald Trump. And the judges, including the chief judge in the 11th Circuit, Judge Pryor, said basically, what are you doing? You're not supposed to be involved. That's for the executive branch. You're a judge. Go look on the back of your door. Why are you interfering? And now we've reached the point, even though there's been a lot of these one-line paperless orders and, slow footing, trial dates, which are all within the discretion of a trial judge. But now you've got a fundamental misapprehension of law that matters. There is a reason, and as you alluded to, as Jack Smith said in his papers, you're putting at risk 12 different witnesses for the government that are not supposed to be known to anybody but the defense until the day of trial. It'll interfere with their testimony. It puts their life at risk. And this, Judge, and, alluding to, without naming it by name, she's been threatened with an assassination on her with emails and text messages to her chambers. Judge Chutkin, as you referenced, has. Every judge has. And they quote I love when they quote Judge Reinhardt, who's the magistrate judge who we don't talk about a lot. He's almost been assigned to the dustbins of history, but he is that really good, sober, appropriate, mature federal magistrate judge under Judge Cannon, who addressed the entire search warrant issue, listening to the evidence, finding probable the search warrant, and ultimately being upheld. He quoted the very reasons why you protect witnesses in this case, and potential witnesses, Jenks material, and grand jury secrecy, and outline all the ways that Donald Trump and the people around him have doxed, attacked, and threatened witnesses, and they just take a cut and paste right out of Judge Reinhardt and stick it into the filing with Cannon. They've given her a chance. She's hit temporary pause, recognizing that I don't know how she missed the wrong standard. And yes, that is an F up of epic proportions. That is not only reversible error, but will get you in trouble with your bosses of the 11th Circuit. I mean, that's a big miss to say you needed to meet the standard of clear and convincing, or whatever it was, instead of just the lower good faith in asking for it. And they even put her back on her own heels and said to the judge, "You're the one. And we have operated under the assumption that all of this is confidential because you signed a confidentiality order that required everybody to keep private names and rank and serial number of people. And now you're telling me that you're going to disclose to the media 12 witnesses? I mean, what is going on?" But fortunately for justice, this is where you and I end up. This is now, if she screws up the motion for reconsideration, she's giving Donald Trump an opportunity to respond to a sort of full briefing on it. She screws that up and she doesn't reverse course and seal again or don't seal. He has a fast track ticket right to the 11th Circuit, and he probably has another one, which you touched on, and I know you'll be doing a hot take on it later, which is this whole issue of she's ordered him independently on a related issue to unseal a document like by today. So if by today that doesn't happen, he's got no choice but to do something about it, probably at the 11th Circuit, or get relief somehow, because he's not going to be sending over to Donald Trump this unredacted, unsealed document.
Yeah, she ordered him to turn over in a sealed fashion a document that was submitted ex parte, meaning just to the court, and under seal, meaning confidential from the public docket, that involved threats against a witness. The reason that it was turned over in an ex parte fashion and not turned over to Trump is it really doesn't have anything specifically to do with this underlying case. But what it reflects is, when it comes to the manifest injustice part of Special Counsel Jack Smith's motion for reconsideration, is showing how a witness is being threatened and how there's another United States Attorney's Office criminal investigation currently taking place, and potentially with the implications being, is Donald Trump or one of the co-defendants or someone who is an unindicted co-conspirator here involved in pushing these types of threats, that's one of the reasons why you'd want to submit it ex parte to the judge. Otherwise, look, if it is documents that have some relevance to the case, it should be turned over under a protective order to a criminal defendant, unless, of course, it's really not related to the case, or there could be a criminal investigation taking place into somebody who's involved in the case, and that there's this additional need for it. It has nothing to do with this case. But look, Judge Cannon is clearly fumbling the ball. And, one of the things she did, though, fumbling would be putting it nicely, she required Trump to respond to the motion for reconsideration by, I think it was about February 23rd. So again, her dates and deadlines, she's using the paperless orders as a way to push all of these dates and deadlines back, which I'll leave everybody with this thought. While that is certainly frustrating and upsetting, and this is an easy case, the documents case, ultimately Judge Cannon is creating kind of ethical and judicial conundrums for herself that will have to be addressed sometime in the future. Like anything, where you try to ignore a small pain that grows into a bigger pain that grows into before you know it, you ultimately have to address a ruling. And she's compounding the problem instead of surgically dealing seriatim one by one with the issues as they arise. So that will only eventually result in a cluster, what. The question is just, when does that happen itself? Meanwhile, you have the Manhattan District Attorney case still scheduled for March 25th. We have the DC Circuit ruling, meaning the DC federal criminal case could start getting back into back into full swing. We'll see what the Supreme Court ultimately does or doesn't do there. And then we're looking at ultimately, potentially back-to-back criminal trials, back-to-back Trump being convicted of a felon, being convicted as a felon multiple times. And then ultimately you have Judge Eileen Cannon, her case getting kind of pushed back, to 2025 or later. And ultimately, at that time, with Trump being a convicted felon, I think Special Counsel Jack Smith can even take kind of more robust and aggressive actions against Judge Cannon at that time, and it actually plays itself out in, I think, in a better sequence if you were to have, alternatively the Manhattan DA case and then DC, or DC, then Manhattan DA. I'm perfectly fine with that, with Trump being hit with verdicts and judgments in the amount of over $500 million, $500 million.
One comment on that before you leave, because we'll follow it closely on Legal AF and Meidas. 15th of next week on Thursday, big red letter day for Donald Trump. We're going to get a final hearing by Judge Merchan on when he's going to actually set that. We've Stormy Daniels, Manhattan District Attorney, prosecution of Donald Trump. It's been on the books for the 24th, but he set a hearing for next Thursday to really decide what to do. By that time, he may have spoken to Judge Chutkan. We'll know on Monday whether Donald Trump is taking the appeal to the Supreme Court. We'll know whether Roberts does a temporary administrative stay of the case on the D.C. Court of Appeals issue pending a full result, or he just rejects it. If he just rejects it, and that's the data point that Judge Merchan has, he may have already picked up the phone and spoken to Judge Chutkan, and we'll have to see how they've arranged the two trials that you've just talked about. Who is going to go first? And we'll know more Thursday. And that's also the day, just to anticipate next week's show, that's also the day that Judge McAfee, if he holds his evidentiary hearing on whether to remove Fani Willis and Nathan Wade as prosecutors and or dismiss the indictment, he's going to hold it on Thursday. Well, if you like lawyers who know what they're talking about at the intersection of law, politics, and justice, look no further than Legal AF on the MeidasTouch Network. We do a show like that every Wednesday and Saturday at 8 p.m. Eastern Time, right here on this YouTube channel. Don't change the dial. Free subscribe and help them get to 3 million subscribers before the end of 2024, before the election. You can help us accomplish that. We do segments like that one, about 4 or 5 every show. On Wednesdays, it's me and Karen Freeman Agnifilo. On Saturdays, me and Ben Meiselas. And then we, the leaders of Legal AF, do hot takes like this one about every hour of every day in real time to keep you up to date at the intersection of law, politics, and justice. If you know all about Legal AF and you're already a supporter and you're in our audience, we thank you sincerely from the bottom of our pod. Take that clip. It's a great way. It's like a gateway podlet. Send it to friends and family and those in your life. Tell them about Legal AF and say, that podcast that I love, here's an example of it, and ask them to join our journey as part of their own. If you don't know anything about Legal AF, there's an example. I'm Michael Popok. That was Legal AF. And join our audience. We'd appreciate it. We think you would find it to be a satisfying hour of your time once or twice a week on the MeidasTouch Network. So until my next Legal AF, until my next hot take, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.